When clarity matters most, Northgene makes legal DNA testing simple and reliable. Our accredited tests deliver accurate, court-admissible results, helping family lawyers and their clients resolve matters quickly and confidently. Learn more at northgene.co.uk.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello and welcome along to the latest Today's Family Lawyer podcast. Today we have, let's describe him as family law royalty on the discussion. It's Alan Larkin. Alan is the founder of Nova and co-founder of Family Law Partners, where he is head of innovation. And part of the discussion today is talking about what that means for you, Alan, and also for the business. I think it's also worthwhile highlighting to listeners that you have recently been awarded an honorary doctorate from the University of Brighton for your sustained impact on the legal profession, I think said the press release. Fabulous to have you on the podcast. I do want to explore that as well as the technology piece, but thanks so much for joining.
Thank you very much, David.
Let's dive right into that first bit. Tell us a little bit about yourself. Who are you? What do you do? What does a head of innovation do at a law firm these days, Alan?
That's a brilliant first question, David. And I'm hoping someday one of my friends might tell me what it is I do as head of innovation. It probably reflects a fascination with me going back 15 years about technology and the way it could try and improve the ability of clients to instruct people like me, a family lawyer, and access to justice. So as innovation, the last 15 years, I've been really focused on saying what processes do we have in place? To what extent are they actually wrapped around a client-first experience? And the answer, no spoilers here, is that most of them are not for solicitors. So my job, my mission has really been put the client first, have a look at that process, chuck it out if it's not working for the clients. And then go beyond that, to what extent could we find technology, new software that would make our clients' lives easier? And by extrapolation, the more we can make clients' experience a better one in coming to us and instructing us, the more we'll get advantages as lawyers. But effectively, I guess my innovation journey started when I couldn't find the software that I wanted. And this is going back to 2011. So I ended up, David, creating it myself because I couldn't find it on the market.
I heard that story before.
So that's the story of Nova Engage, of course, the client onboarding application. But I was astonished that I couldn't find it anywhere, not in any other professional sector that I could have adapted. So I have no coding experience. I didn't have computers at school. I didn't have a computer until I was age 30. All very much, very late acts for me. In a lot of ways in my life, I come late to everything, but hopefully in a more rounded way. But I decided to create my own software.
We'll come on to the software and the technology shortly. Tell me about the doctorate that you've received from University of Brighton. I said with my tongue in my cheek that the press release was very effusive about your role, but you've done some incredible work around access to justice and actually put that into action in your own firm as well.
I must admit, I was astonished when the university told me that they were going to give me this honorary doctorate. And to some extent, I still feel like I need more time to really earn the accolade. But I guess it was a recognition of a couple of things. One is that I've been invested for quite a long time now in the technology space, but specifically on access to justice. And trying, just puzzling myself as an individual who has a background from the voluntary sector as well, David. I didn't qualify as a lawyer until I was 35. But coming from a voluntary sector, I struggled to understand why lawyers didn't do more to make it easier for the public to instruct them. And especially with something like family law, where we know that people's inability to get really timely advice impacts not just them, the conflict levels impact their children, their ability to perform well at school. It creates health conditions. The impact on society to resolve relationship problems and conflict is really profound. So my overriding passion in the last 15 years was, could I look at technology as a way of giving and imparting information to the public that they could take actionable steps upon to reduce conflict, to see better ways of resolving their familial conflicts, both for themselves and for their children. So in terms of that, we've just mentioned the fact I ended up creating my own software. I've been very invested in that space. And also just recognizing that as lawyers as well, we can look at technology, we can write all the blog posts in the world that we want to about, oh, we should improve access to the profession. So it's not just about access to justice for our clients and potential clients. We also need the legal profession to reflect a wider grouping, a proper representative demographic. So I felt, I guess you would probably say I'm from a working class background. I went to a secondary modern school, failed my 11 plus, buggered up my A levels. I am probably from a person who didn't have anyone else in my life who said this is what university is like. So it's not just about access to justice, it's also, can we have lawyers? Can we increase the diversity in the profession? So part of the award of the honorary doctorate was to recognise that in Family Law Partners some years ago, we created scholarships with the University of Brighton. And the scholarships were to try and give financial support and mentoring support, professional development support throughout the 3 years of an undergraduate law degree. We said to the university, you tell us who you identify as being students who need that additional support. And very often, David, they were from working class backgrounds and are, or they're from care backgrounds. They're from backgrounds where they don't have uncles or aunties who are in law or in any professions who can explain to them why they should be good enough to enter the professions. So for us as a firm, it was a really important commitment to commit hard money and hard time to developing these younger lawyers as they go through their careers. So for us, it was scratching an itch, I guess, to try and do some good, to physically do some good, not just to bloody talk about it all the time and then turn over the page. Okay, it was to make a difference now and hopefully to pay that forward.
Much to be applauded in that sentiment, Alan. Let's talk about your work in technology. Let's talk about this passion that you have. It comes across in spades while we've been chatting already. You couldn't find what you were looking for back in 2011. What made you sort of think that it could be solved by technology? Because the law, and particularly family law, is a very interpersonal relationship, isn't it, with our clients? So why does technology have a role to play?
So if you think about it, I mentioned before, always adopt a client-first experience. And when I sat back, and I've been doing family law for about 10, 12 years at this point, and I sat back and I thought, what's the first encounter that a client really has with us? And it's the first consultation. And I thought the experience for a client who's under significant stress, of course, remember, this is a backdrop of family breakdown and separation. Their experiences as they come into a professional environment are usually opposite someone in a suit, all suited and booted, all very adversarial, sitting across a big table. The office might be very, look beautiful, look chic, or it might be a little bit downtrodden and a heel. Regardless of that, they're opposite a professional at a very intimate and challenging moment in their lives. And what happens? They're bombarded with questions. And I measured this, I'm anally retentive in terms of measuring stuff like this, with a tech interest as well. And it takes 1 hour and 20 minutes to ask sufficient questions of a client before you could get around to giving bespoke and safe advice or guidance. If there are elevated levels of distress, that's closer to 2 hours. So a client comes in for us at a moment of dire need in their lives, and the value piece to them is advice and guidance, which we endlessly defer in that first consultation by question after question after question, when their ability to cognitively understand what's going on is already impaired by the levels of distress. So you ask me, what's the point? How can technology help with that? Well, imagine, and I did this 15 years ago, I said, imagine, Alan, if you could turn that dynamic on its head. And when that person comes in, you know everything about them. The conflict levels, their journey, the children, the ages. Have the children got special needs? Are they having a difficult time at school? What's the conflict level between this client and their spouse? What can I do right off the bat, the very first minute of the conversation, to put them at ease? And armed with that information to say, I hear you, I see you, I understand the challenges you'll get. I understand you. I'm the arm around the shoulder. I can do that in the first 60 seconds of that consultation, not endlessly defer the advice that they're desperately waiting for. And that's where technology came in. Could I build a brilliant client onboarding system, hugely personalized, using the first name of the clients and the children and their spouse? Could I get all the hard factual information I needed as a lawyer to do my job and give advice? But at the same time, could I surface the emotional information that I needed to understand not just where that client's head was at, but also where their heart was? What was their pain? How could I, armed with that information before the very first time they stepped foot inside the office, how could I prep and give them the best possible experience of a first encounter with the family law profession? That was the whole point of the technology, and that's what I created.
As you're chatting, I'm thinking to myself, what you're trying to create here is almost a hybrid between the legal elements of family law and then that emotional element of it. What kind of, presumably you kind of had the input into the legal bit, what kind of input did you have into that emotional stuff and really trying to surface, as you say, the emotional elements to what the client's going through?
Well, do you know what I did? At the very first design stage of the software, and I was thinking, what do I want to achieve here? I thought I need to educate myself. And I got every bit of research. So the Legal Services Consumer Panel, the board, the SRA, the Ombudsman, Legal Ombudsman, the Law Society, Resolution, group of family specialist practitioners. I read every single bit of research I could find. And I created a matrix. And I basically had in one column, what do clients want from family lawyers? What do they actually want to achieve? And it was a bit of an eye-opener for me. So I could see that what they really wanted was direction. They did need that arm around the shoulder because all of their other anchors in life, the relationship was going or gone. The relationship with their children was also under difficulty. If you're a bloke, you probably don't think you can speak to your best mates about this. You certainly can't speak to your work colleagues, even if the work is suffering. So I looked at this and I thought, God, we really get so many things wrong in this first consultation. So I used all of this research to look at the way in which clients felt. And I thought, can I use a software application to give those clients a soft landing? So if I know that they're feeling lack of control, how can I give reinforcing messages, nudges, words of encouragement to say, it's common to feel like this in your circumstances. Don't worry about it. Everyone feels like this. Don't worry about this because this is what family lawyers are trained to do, to put you in that better place. So I can have all of these reinforcements, all of these normalization techniques built into the software. But effectively, David, I just went out and did my homework and all of this information was out there. I spent about 3 months just putting it into a graph and saying, this is what I need to make this person feel. This is how they feel coming in. This is the dynamic I need to change by the time they've come through the bits of software that I would like to create. And I want to wrap it up in a bow and present it digitally to that family law practitioner so they can do their best bit of work they will ever do in their lives in that first consultation. So homework, that's what it comes down to.
I don't necessarily play devil's advocate in the course of these podcasts, but I have in the back of my head the professionals sat there saying to you and I in the course of this discussion, technology simply cannot replace that face-to-face element, that empathetic element that sitting across from a professional provides. Do you think there is a risk that we lose some of that interpersonal connection by using technology?
We all know that family law cases can be complicated, which is why you and your client deserve reliable, hassle-free drug and alcohol testing services. From hair testing to abstinence monitoring, we can help. Visit lextalks.co.uk for more information.
The simple answer is no, we don't. And the reason I'm going to say that, and I will die on this hill, okay, is that Never Engaged, that very first bit of software I built, the client onboarding application, it's 11 years old. It's had over 18,000 clients use it. It's on its 5th version. So in the very early days, when I created the first version, I had those anxieties. What am I doing? What's the point of this? And the point very simply was not to replace lawyers. And I remember my first Law Society talk. This is 10 years ago, when someone had wind that I was creating some software and said, come and talk to us. The very first question from the audience was, why are you trying to replace lawyers? And I said, in what part of my talk did you hear me say, I want to replace lawyers? Why would I replace myself? Why would I replace all the brilliant colleagues I work with? I want to make it easier for the public to access the human elements of what lawyers bring. All of the gold standard work is human delivered in the meetings, in dispute resolution, in the many ways in which family law clients will be put in a better place by the use of the software and the use of the advice given when software gives us that soft landing. I never wanted to replace lawyers. It was to make the job of lawyers easier by wrapping the client experience as being the first consideration. Every single time I have iterated Engage to be a better experience for the clients, it's ended up giving a dividend for the lawyers. I didn't mean to do that, by the way. A lot of it I didn't foretell. I'm actually not a genius at all. And you mentioned I was royalty before. In a lot of ways, the king has no clothes. I learned as much as anyone else as I went along on this iterative technology journey. Honestly, it's so important. It's not to replace lawyers, because that's still the value piece, is to get in front of a human and to have that human experience. I'm just talking about technological soft landings. That's all it is.
Does this software provide any advice at all?
No, never intended to. The advice must always come from the human, but it can provide guidance. It can provide answers to common questions, such as, different types of joint ownership. It confuses people. Lawyers take up a lot of time in the initial consultation explaining what a notice of severance is, because someone's probably read a blog about it, or they've read about spousal maintenance, and they have all these questions. So we have a very rich contextual help function in Engage. So it's very personalized, because we've got the names of the parties. So the contextual help just says, this is what we mean by this question. Or it will acknowledge an anxiety and say, it's okay to feel like this. Let's explain what some psychologists have called the 7 levels of separation. There will be some, fear. There will be some anger, but you will move through these stages. You may move back on some of the stages, but it's okay to feel like this. So the contextual help is constantly putting the person at ease. And in a sense, that's a really crucial operation to make sure that the lawyer is then handed a client in that first consultation where the stress levels are reduced. And the importance of that is that cognitively, there's more capacity in the brain. The fight and flight response, the flight is reduced, and the ability for the client to listen really carefully to what's being said by the lawyer.
Thinking about the conversation we've had about access to justice, on a practical level, did you set out to create a way in which this would be inexpensive for clients, or is that a happy byproduct, Alan?
I always intended the software to be free at the point of access to clients. So I mentioned before, I come from a voluntary background. I found it hard. It was a struggle for me personally to think, as a lawyer, I've got all of this information and knowledge, but you can only have it from me if you pay. That was a difficulty for me as a younger professional. But it's really important for me as an individual to think that anything I create, if I can make it free to clients, that's great. I will charge lawyers, and I have done laterally, for the software, but I think that's a good bargain because I do give benefit. We may come upon that later in terms of the benefits of the lawyers, but it has to be free. And the reason for that is I did legal aid for the first 15 years of my career. And I knew that even if I put a £5 paywall in front of the software I was creating to the public, it would disenfranchise enough people who desperately needed help. So I think there is a bargain and there's a balance here. I think we can create software that is free at the point of access to the public, but it will also give dividends to professionals like family lawyers. It's a healthy bargain and it's a good one to have. So for me, it's always got to be free. Otherwise, what is the bloody point of doing it?
Back with my devil's advocate hat on, what about the traits of domestic abuse and the challenges that presents? I mean, we've talked in the sector about this increase. I think most professionals sort of recognise there's not an increase in domestic abuse, there's an increase in knowing about it and knowing that it's happening. But here is a solution that potentially misses some of those traits if we're not too careful.
It's a really good question. And again, every time I set out to create a different iteration of the software, I would explore those anxieties myself and thinking, should I do this? Is this going a bit too far? Am I pushing the envelope a bit too away from the human experience? We do have questions about domestic abuse and coercive control in Engage. We've had them for 5 years. And the reason that I put them in is that I thought that the screening procedures by lawyers, a lot of us do a lot of training on screening for domestic violence. It's not uniform. And it occurred to me that I should ask a question about it, because I thought, is it better for a user in a private place in their own time to reflect upon these questions? Because these questions like this can be triggering, and I recognized this and I agonized. But you know what happened? I had a discussion, a really fascinating one. And one of the benefits of being involved in software is I get to have lots of interesting conversations with colleagues around the country. And I had a conversation with someone who genuinely, David, is family law royalty, unlike me. And that's Angela Lake Carroll, who's probably trained more lawyers and mediators and collaborative lawyers than we've had opt-iners between us. And she said to me, she said, it's brilliant and you must ask this question in a digital experience. I said, why? She said, because my experience is that people struggle when they're asked that question in the first consultation, either because they have suppressed their feelings about it and suddenly to be asked that question, when they're already struggling with lots of other anxieties, they will often clam up and won't answer honestly, or it can trigger those emotions. So she said, you must ask it. And it's brilliant to ask it in the digital experience, because that person can reflect, they can have that emotional response if they got, but they can process it and they can be honest about it. And everything in the software I create has an actionable outcome. I don't just leave it. If there's a feeling that my questions are revoked, I always say, what do you want to do about that? What would you like your lawyer to do about it? Is it you just want the lawyer to be aware of it? It's historic, but you appreciate them knowing, or do they need to take action on this? Is it urgent? I don't think there's any question now that I wouldn't ask in a digital onboarding experience, but domestic violence, I've thought about for 6 months before I put it in. We have feedback from 60% of our public users, which is incredibly high for a digital experience. So I know not one single user has ever given me pushback on asking that question. Quite the reverse. They've appreciated being asked about it, like other questions that some practitioners might find difficult to broach, like the effect of the menopause or perimenopause. How many male practitioners, not very many in family law, tends to be female profession, but how many men would feel comfortable asking a female client about the menopause? We asked it. We did that 3 years ago. We have really good feedback from the user saying, I really appreciate you asking that question. Because yes, it has. Even from male users saying, I think it is a factor in the separation. They're difficult questions to ask, David. Even for some practitioners, they might feel quite confident. We have the license and the permission from the users by using an intelligent framing in the questions to get those answers. And a lot of practitioners appreciate the fact that we've already broached and gone into that territory, so they can do extra preparation if they have a more vulnerable client.
We've talked pretty extensively about your passion for providing this to clients and some of the client experience. Let's switch and focus a little bit about the experience of the lawyer here. What are the kind of key benefits? And you've alluded to the fact that there are a number for professionals, but what are the kind of key benefits to lawyers in using this sort of technology in your view?
Yeah, so really interesting the last 11 years of just sitting within a family law team as I do and seeing how the lawyers are using the technology. I said before, David, that everything is client first in terms of the software, but let me just try and isolate a few of the benefits I do think it gives to the lawyers. The first thing is, I mentioned I did my homework before. What do clients really want? What do they want to avoid? I also did my homework on risk, and I looked at all of the SRA cases. I got PII data from our own insurers. I looked at the Leo cases as well. And I thought risk is a massive inhibiting factor for lawyers. That's why they ask so many questions in the first consultation. It's why they're so hesitant. If they are being asked by the client to say, so should I sell the family home? Is it okay if I don't claim upon his pension? When they don't feel they've got enough information, it's all like maybe, ifs. Well, it depends. That's useless for a client. They want something actionable. So I thought really hard about this risk. By looking at all the data, I could engineer out the risk for lawyers. And the most common risk for family lawyers at the beginning of the retainer is they don't ask the right questions. Well, Engage always asks the right questions, doesn't forget. Also, that they haven't understood the information that they're given. Again, Engage does some of the heavy lifting in surfacing some of the links between different questions. So I thought if I can reduce the risk, then I might put the family lawyers at a bit more ease to know that that's in the background there. So it's about having the right information before we open our mouths and say something that the client construes as advice. So that's the first thing. And just to say that I can demonstrate that, the family law partners, we've had our PII insurance premium reduced 4 times by travellers because I use their data to create a risk reduction profile when I had the software. And this is originally from 13 years ago. So risk to begin with. The second one is about conversion. So we've seen Google's AI overview reduce blog traffic to most family law firms by about 35%. That's a big hit in terms of our pipeline of work. So if we're going to have a reduction in the pipeline of work, we have to move heaven and earth to have a conversion if we can. So why would you not have a onboarding experience, give you all of that information about the client, where the head and the heart is at, and then use that to give a really brilliant first experience. We can go into advice from the first minute of the session. It's safe to do so. Remember the risk profile? We've already ironed that out. So you can start giving advice in the first couple of minutes. Now that will always aid a conversion event, okay? And we have to really get the dial to have an uptick in terms of the percentile conversions. So the difference between having a 35% conversion in a law firm on a first consultation of 40% is, depending upon the size of your team, that can be tens of thousands, if not hundreds of thousands of pounds of revenue. So that's the second thing. Commercially, you're going to have a conversion event. Thirdly, this is really interesting. This is qualitative, and this is because I sit in a family law team. I can observe this, even though I have no way of measuring it. But I love talking about this stuff. It's really fascinating. It's that the lawyers were saying, it's almost like they're getting back to enjoying the day job. And I'd say, well, what does that mean? Can you unpack that for me? And they were saying, well, it's a little bit like when I go with a client and I go to counsel, and you go to a conference of counsel, and the client comes out of the conference of counsel and they go, God, that person was amazing. Wasn't it brilliant? It's like they knew me. They had a complete command of all the facts. They were really clear in their advice, and they gave me a really purposeful sense of direction. And you're walking away with the client going, yeah, well, that's only because I gave them the best bloody brief they could possibly have. So I realized when the family lawyers were saying to me, God, I really like this Engage submission. You know, what is it about the change in the client dynamic? It's a bit like counsel. Suddenly they're super shiny because the client's coming saying, God, that lawyer really got me. It was amazing. It was like they could see inside my head. Well, the client's giving us all the information. We are like mini counsel, suddenly going from being data interrogators to being purveyors of advice and guidance, which your counsel do. That's why they look so super shiny and magisterial in those first conferences, because we've given them all the information. We briefed them so brilliantly. So that's what Engage was doing. So the lawyers were saying, I always had this conception of being a lawyer, and especially a family lawyer, of giving solutions. So what I'm able to do in that first meeting is move much more quickly to that value proposition for the client. I can see their shoulders dropping. I can see the sort of steam come out of the head, the release of stress. But also, I love giving advice. I love giving the solutions. I love laying out the landscape for getting that client to a better place. They just have a short circuit to that if they've got the information beforehand. So in a way, some of the lawyers, the ones who've been in their job for like 15 years, were saying almost like they were falling back in love with that initial consultation. That was really interesting to me. So I would say that's a pretty big benefit if you're feeling a little bit jaded. It's a completely different dynamic in the client consultation. Get back to what you trained to do: advice, guidance and strategy. Stop being a bloody data collector.
Is the trade-off there then, particularly with the technology, that your opportunity to fee earn during that opening series of questions that you might normally do, and you've identified that's an hour and 20 minutes, 2 hours, whatever it might be, it becomes limited then?
No. So again, this is brilliant because I sit in a law firm, so I can measure this stuff. So let me tie it back to this. One of the very first questions I used to get, apart from why you're trying to replace lawyers, is I'm never going to use this because I charge for this inefficient information gathering. And I should say, but why are you doing it? And where's the value? Because the clients are telling us in the research that there is no value. There's none whatsoever. So again, I'm really honest about this. I would always play out these little anxieties myself when I was creating and iterating this software. I used to think, God, does it mean that we really would have a big black hole in what would have been a chargeable event in the first consultation? What actually happened is that we didn't stop charging for first consultations and the clients didn't mind. And I thought, well, okay, if we carry on charging, would it mean that where we may be with them for 2 hours in the first consultation, we're suddenly only with them for 20 minutes? Is that going to be the commercial hit? No. So I can tell you the metrics were there was a 10-minute difference. There was nothing as an average, a 10-minute difference. The difference was, David, that we were not asking lots of questions. We were giving value from the very beginning. The clients were much more engaged and immersed in that and wanting to get more and more in terms of actionable advice. So because they saw the value, they stopped clock watching as much. And even in some of those fixed fee consultations, the lawyers might be saying, well, I think, we've got as much out of this as we possibly can. The clients are saying, no, it's brilliant. And just asking a bit more questions, just being a bit more in the moment, as they often are not because of the stress levels. For men, it's like they can't remember the middle names of their children. They get the birthdays mixed up. Horrible to add that stress onto an already stressful situation for them, but you can see them freezing in the consultation. They don't have that. We've got it already. And the first names of the kids. So it's just about adding those little points of value, I think, that make a massive world of difference to that interaction between the client and the professional. And it's for the professionals, it's about being the best version of ourselves from the very first second of that very first client meeting. And that's what the clients want from us. So that's a marriage in heaven.
Just thinking about the way that family law is developing, thinking about collaborative law, for example, do you envisage that this data can then be shared, and do you get permissions for this data to be shared with other professionals that you might involve in the case?
Yeah, so I'm massively invested in dispute resolution outside of the court. I was a collaborative lawyer myself, and I love that work, David. It was the best work I ever did as a lawyer. So I loved working with another family law professional and looking at solutions that benefited the whole of the family. So there is a huge piece, and there always has been, about solutions outside of the court in Engage. So we surface all of the different dispute resolution models. We track whether they've had experience. So have they come from mediation before they come in to see this new lawyer? Was the mediation successful? So they just want a consent order. Has it stalled? Can the lawyer rescue it? Or is it completely, unfortunately, failed? And we have to look at another resolution model. So it's hugely important and a way of making sure that our public users, our potential clients, have a sense of agency if we can explain these models to them. And I explain in very rich detail. And the more I explain to them, the more they tell me. Remember, 60% feedback from the public users. They appreciate having this, almost tears of relief. I know that these better solutions exist. So when it comes to the technology, yes, we have lawyers who use the technology for mediation clients. They send the Engage link out to both clients. They use it for collaborative working, for hybrid mediation, and also in the newest model, the newest kid on the block, which is the one lawyer, one couple model. So again, you can have both clients completing the form and also measuring just, are they providing the same set of facts, but also are they in the same place in terms of the conflict or the level of separation? So it lends itself absolutely to forms of resolution outside the family court. And that was always my intention. That was a very conscious decision. A bit of a passion project for me, as you can probably tell.
I think, like with a lot of technology, there is still a barrier in the sense that we have to bring clients along on this journey with us, don't we? We have to get them to understand that this is a way in which you can engage with your lawyer. They have this very traditional view of, as we've already talked about in the discussion, going to the office, sitting down, that adversarial, one side of the desk, the other side of the desk, suited and booted, all that kind of stuff. This is a very different way of engaging with lawyers that people won't necessarily recognise. So we've got some education work to do there, haven't we, Alan?
We have. Public education is the key here. So we know there's a really well trotted out statistic, I think it comes from the SRA originally, that 45% of the British public can only name one alternative to the court. And that's usually mediation. So 55% can't name anything. So as family lawyers, we know that there are about 9 different flavours of dispute resolution we could offer to the public. And the public are utterly ignorant of them. And I think that it behoves those of us who might be invested in technology and the ability of technology to scale public education messages, which is what I've always been invested in, and to explain to the public. So I know from feedback from the users of Engage, I know from various experiments I've done with other bits of technology, that the public are genuinely as ignorant as that statistic suggests. But I can also tell you from first-hand experience that those users are deeply grateful for the fact that family practitioners can offer alternatives to the court. The research shows that family consumers of law do not want to go to court. But at the same time, the public education piece is showing us that they have no idea about these other skill sets. So I think if we can use the technology to give public education messages about hybrid mediation, collaborative arbitration, everything the family lawyers have invested in, then we are doing good work. We will make it easier for those members of the public not to get distracted or diverted to a horrible court experience before the conflict gets too high. Can we have technology as that early intervention agent to get in there, explain these better processes, communicate the value propositions for why these models are better, and say, look, the people who can offer these brilliant models are called family lawyers, and they're over here. Let's direct you towards them. That, to me, seems like a really good job of work if we can just achieve it.
And a fairly neat way to sum up the discussion as well, Alan, because we're out of time. It's been great to have you on the podcast. I'm very appreciative of you sharing your insight, and I think it's fair to say your passion has come across in spades as well. So thank you very much indeed for joining.
Cheers. Thank you very much.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Alan. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.